Before we proceed, I request Honorable Shri M.R. Kumbhar, Member Industrial Court, Honorable Shri D.S. Kolte Sir, Honorable Shri S.D. Bouchkar Sir, to come and occupy the seat as panelist of this session. I think the first team is already here. Now to few rules. As parliamentarians, we come across a hot and contested debate. But we should not forget that we are students of law, and therefore we should not forget that our behavior should be one as lawyers also, one of decency, as well as we should not forget that we should not cross the limits as what is seen. I think all the students here are aware about the time which is allotted to them, and the first team which I call upon is the Emerald House. I request the team of Rizvi College of Law, Bandra, who represent Emerald House, to address, come forward and kindly be seated. One of you would be chairing the seat of the speaker. The topic which is given, which is picked up. Okay, before we start off, I would only request Honorable Shri Navkar Sir and Honorable Shri Dinesh Surana Sir to felicitate the panelists. Let's have a round of applause for the panelists who are going to judge you today. Thank you. May I request the speaker of this Team Emerald, Mr. Sukesh, to come forward and occupy the seat as the speaker. We have a bill which is to be introduced, which is Occupational Safety, Health and Working Conditions Code 2020. And we have the two sides, one which is favoring the bill and the other which is opposing the bill. So now we would begin with the session.
Good morning, Honorable Speaker, Honorable Members of the Parliament, and everyone present here. It gives me great pleasure to give you a brief introduction of the bill and give you brief points of certain provisions made in Chapter 1 and Chapter 2 of the Occupational Safety, Health and Working Condition Code 2020. Total number of workers comprising of organized and unorganized sectors in India are more than 50 crore. It is for the first time that any government has cared for the workers in both organized and unorganized sectors and their families. Earlier, the working class was entangled in a web of multiple labor legislations. The central government has taken a revolutionary step in the right direction to provide them with freedom in true sense. Labor falls in the concurrent list. Therefore, both Parliament and state legislatures can make laws to regulate labor. Central government has stated that there are over 100 state and 40 central labor laws. The central government has stated labor laws regulating various aspects of labor, such as resolution of industrial disputes, working conditions, social security, and wages. The Second National Commission on Labor found the existing legislations to be very complicated, to be very complex, with archaic provisions and inconsistent definitions. To improve ease of compliance and ensure uniformity in labor laws, it recommended the consolidation of central labor laws into broader groups such as industrial relations, wages, social security, safety, and welfare conditions. This code amalgamated various acts such as the Factories Act 1948, the Plantation Labor Act 1951, the Mines Act 1952, the Working Journalist and Other Newspaper Employees Act 1955, etc. I'll start with a small brief on Chapter 1, which includes Section 1 and 2 of this code. Section 1 provides the short title for the code. It also tells us about the commencement and the application of the code. Section 2 provides key definitions of terms which are further mentioned in the code. Now, we had old labor laws. Some of the definitions in our new labor laws have been amended. Definitions like contract labor, establishments, employee, employer, factory, principal employer, hazardous process, wages, worker. I would like to move on to Chapter 2, which includes Section 3, 4, and 5. Section 3 talks about the registration of any establishment via online application sent to a registering officer. I would like to point out to this House that Interstate Migrant Workers Act 1979 has been comprehensively addressed in the OSH code. Earlier, only workers appointed by the contractor were recognized as interstate migrant workers. However, under the new provisions of the law, workers can be Atmanirbhar, as they can register themselves as interstate migrant workers on the national portal. By this provision, the worker would get a legal identity which would enable them to get benefits of all social schemes. Section 4 provides appeals against orders made under Section 3 of the code, and Section 5 provides the responsibility of the employer to send notice to the central government before any commencement or cessation of any operation carried out in the establishment. Any objections?
Good morning, everyone. With the permission of Mr. Speaker, I speak against the bill. I rise to inform the House that there are certain workers that are not covered in the proposed bill. The establishments which have the strength of less than 10 workers do not come under the ambit of this bill. Due to such provision, mandatory social care benefits such as provident fund, pensions, and the safety regulations that are applicable in this bill are not applicable to the establishments which have the strength of 10 or less workers. It is also important to know that the Second Labour Commission recommended a separate law for small units for less than 20 workers, with provisions for payment of wages, social security, welfare facilities, and resolution of disputes. Hence, I would like to ask the honourable member as to why the recommendations were not accepted by the government in this bill.
I would like to appreciate the point raised by the honourable member, but I would like to also point out that one of the main reasons this code was made was to make the laws easier to comply with. So applications on labour law based on number of employees is desirable to reduce the compliance burden on industries and to promote economic growth. I feel that should suffice your answer.
Honourable member, this tells us that the application of labour laws based on the number of employees is desirable to reduce compliance burden on industries and promote economic growth. However, such low numeric thresholds may create adverse incentives for establishments' sizes to remain small in order to avoid complying with the labour resolutions. So how is the purpose of excluding them served? Therefore, I urge the government to consider including all establishments irrespective of number of the workers in the purview of the bill.
I would like to add on to this point that this definition of establishment for 10 or more workers was also to protect small businesses from costly compliance efforts. That should suffice.
The honourable the honourable member, I would like you to understand that the safety regulations that are mentioned in this act should be mandated for all, irrespective of the establishments, may it be small or big. I further want to go on the point number 2, where I would like to draw the attention of the honourable member towards the provisions of unregulated gig and platform workers. The Standing Committee of Labour had examined and recommended that there shall be an expansion of definition of unorganized workers to include gig and platform workers. Number two, the definition of gig workers should have been more specific to avoid misinterpretation. And expanding the definition of platform workers to enable the inclusion of future models of work. The proposed bill only incorporates the last recommendation. I therefore ask the Honorable Speaker to come ahead and tell us why these provisions were still unclear.
I would like to appreciate the point raised by the honorable member, but I would also like to say that gig workers are self-employed members. They do not come under the traditional definition of an employer and employee. They basically provide professional rendering services. They are not under the purview of worker in the bill. I would also like to request honorable member to refer to section 115 subclause 3, which talks about welfare of unorganized workers. So basically the appropriate government is going to provide fund and provide necessary facilities to all the unorganized workers. I hope that answers your question.
The proposal given by the honorable member is considered. I only hope the benefits given to unregulated workers are fair and proper provisions for implementation of the welfare fund is made so that it reaches to every regulated worker in this country. My third point of objection and recommendation to the honorable member is that in regards to the bill, which contains health and safety provisions for workers in plantations that measure at least 5 hectares. In its report, the committee had noted in assurance from the ministry that workers in plantations which have less than 5 hectares would be covered under this bill. However, this recommendation has unfortunately not been incorporated in the proposed bill. Therefore, I urge the government to accept the recommendation of the committee and include all plantation workers without the given threshold limits. Thank you.
I would like to appreciate all the objections raised, and I would say that the government will take note of all the recommendations. I would like to invite the second speaker for today.
Good morning, respected Speaker and all other members of the Parliament present in the House. I would like to draw the attention of all the members present in the House on Chapter 3 of the OSH Code 2020. Chapter 3 of the OSH Code 2020 basically deals with the duties of employer and employees elaborated over 10 sections. That is from section 6 to section 15. The major focus of these sections are on the occupational safety and health standards of all the employees employed under factories, mines, dock works, buildings and all other construction works. Various occupations have various degrees of health and safety risks. So for example, the risk involved in a mine worker won't be same as the risk involved for a factory worker. So therefore, this code discreetly explains the duties of employers from different sectors in different fields of work. Then section 6 of the code duly mentions and explains the duties of all employers in general. Like for example, ensuring workplace safety and ensuring proper disposal of hazardous waste, then issuing appointment letters, providing healthy working environment, and also ensures that no charge is levied on the employees regarding maintenance of safety provided to them. Moreover, in case of any accident in place of the workers, which causes some bodily injury or death following the accident, according to section 10, the employer can report to the responsible government about it, about the dangerous occurrences and the diseases faced by the employees, so that the health of the employees can be prioritized over any other occupational need. Moreover, the code also deals with the duties and responsibilities of employee so that they are aware of their safety, and if faces any inherent danger can go to the employer or the supervisor without any restrictions. They are allowed by them and they can place to them their problems and they will gladly hear them. Any objections? Yes.
Thank you, respected speaker, for the recognition. I would like to draw the attention of the House towards a safety provision which has not been mentioned or included in the chapter 3 of this code. The duty of the employer in case of emergency exit. So my recommendations are, all the employers, it is the responsibility of the employer that every employee has proper training about the emergency procedures. It should include how to react in case of emergencies like fires, disaster, earthquake or any disaster. There should be drills so they know how to react when an actual emergency occurs. Even in time of orientation, they should be properly informed about the location of emergency exit, location of the first aid supplies, location of the fire extinguishers, evacuation procedure and muster stations. All business must have portable fire extinguishers available at the workplace. Then a proper pumping system should be there along with the pipelines to provide water to extinguish the fire. There should be smoke detectors and sprinklers. This may differ from establishment to establishment. There should be posters with emergency numbers like number of fire, number of police, number of ambulance present posted at the notice board as well as at different places at the establishment. I recommend appointing an emergency officer who will ensure that there should be that the condition of the fire equipments or emergency equipments are proper. There should be random inspection so that at the time of emergency there is no
I acknowledge the point said by my opposition member, but I would like to draw her attention on the fact that all the points that you have mentioned is already duly noted in the section 6 subsection 1 and 2 of the code. Section 6 subsection 1 deals with all the duties of the employers that you just mentioned, and about the training point, it is already mentioned in subsection 2 that the training of the employees in hazardous situations is mandatory, and it is understood that they will be trained regarding all the emergency exit points and how to keep themselves safe in terms of emergencies. And also in section 87 of the code, it clearly mentions about the emergency standards, which covers all your points. I would like to conclude my argument by telling that this code is basically extensive and absolute. It includes every minute detail taken care of for the safety of the employees and employers and other workers when passed, the laborers would be provided with freedom in true sense. Thank you.
I would like to say that these provisions are not explicitly mentioned. So this is my recommendation, they should be mentioned explicitly, and I will send my report of the recommendations to the speaker.
Your recommendation will be duly noted by the government.
Greetings, respected speaker, honorable parliamentarians and all others present here today. Today, I will be dealing with chapter number 4, which talks about the occupational safety and health of all employees within a particular workplace, be it an office building or be it an on-the-site work construction site. Firstly, I would like to start off by saying that under section 16, the central government has already notified the creation of a National Occupational and Health Safety Advisory Board to ensure that each and every rule, direction, standard and provision under this bill is being covered and is being followed by each and every single employer. It is also to be ensured that the composition of this board has been duly specified in this bill. Also, under section 17, the state governments have the similar permission to create a safety board as well. Furthermore, under section number 18, we specifically state that the central government can declare the safety standards over and above the existing safety standards already mentioned in any factory, mine, or any other place where work or product which is dangerous to human health is being manufactured. For example, BD, cigars, mines, factories, and docks. These are hazardous workplaces specifically for the employees, and therefore the central government may duly notify of special rules and safety measures for the same. Are there any objections?
माननीय स्पीकर महोदय, मला माझे मत मांडण्याची परवानगी दिल्याबद्दल धन्यवाद. व्यावसायिक विषयक सुरक्षा आरोग्य सेवा शर्ती संहिता 2020. माननीय प्रवक्ता, तुम्ही जे व्यावसायिक विषयक सुरक्षा तुम्ही कर्मचाऱ्यांचं म्हणजे जे कामगार आहेत कुठल्याही प्रकारचे कामगार असो त्यांच्या सुरक्षेविषयी तुम्ही या चॅप्टरमध्ये भाष्य करतायत. मला एक प्रश्न विचारायचा आहे तुम्हाला. सुरक्षेमध्ये आत्ताच्या काळामध्ये 80% कामं ही ऑनलाईन पद्धतीने चालू आहेत, बरोबर? मग आता त्या ऑनलाईन पद्धतीने चालू असलेल्या कामांमध्ये काही ऑनलाईन हरॅसमेंट सुद्धा होतात. मग त्याचं प्रोव्हिजन या सेक्शन्समध्ये का नाहीये?
The honorable representative would like to take note of his fellow representatives' points, and indeed, these provisions do not need to be mentioned underneath the specific code because in existence currently, the Information Technology Act of 2000 already states the prevention of online harassment as well as cyberbullying, which may take place in any workspace or even a school or college or any other educational institution. Furthermore, there are various provisions under the Indian Penal Code which take care and which prevent any sort of sexual harassment or sort of bullying which may happen in any sort of work environment. Furthermore, since the online work experience may last for only a short more time, and this bill is obviously tabled with regards to a futuristic demand, the online provisions have not been considered.
फॉर एग्जाम्पल, बट अभी भी मतलब यहाँ पे अभी भी बहुत सारे ऐसे ऑनलाइन हैरेसमेंट के केसेस आ रहे हैं. एग्जाम्पल एक बताता हूँ आपको कि एक दिल्ली की टीचर है, उनके साथ मतलब वो टीचिंग करके चली गई, बट उनके स्टूडेंट ने फॉर एग्जाम्पल किसी ने उनका स्क्रीनशॉट लिया और उसको चित्र विचित्र एकदम ये करके वायरल कर दिया. फिर अब वो टीचर ने सुसाइड किया. तो आफ्टर दैट अभी ये टीचर इस कोड में कहां पे आएगी? आपने बोला इंफॉर्मेशन टेक्नोलॉजी एक्ट है, बट आप अगर ये ऑक्यूपेशनल सेफ्टी व्यावसायिक विषयक सुरक्षा के बारे में बात कर रहे हो तो ये कोड में ऑनलाइन हरासमेंट आना चाहिए. दैट्स माय पॉइंट.
Indeed, respectable speaker, firstly the government would like to announce its sincere sympathies with the teacher who has committed suicide and as well as with her families. However, as I have previously mentioned, if this teacher would have approached her employer and the employer would have taken the relevant steps with regards to the occupational safety code, as the appointment of a welfare officer is very important for the same. However, the recommendations shall be taken into consideration.
You said that the safety would be taken after the incident has taken place. My sincere question to the opposite party is that why after? Why can't the precautions be taken when it is not supposed to happen in the first place?
The precautionary measures have already been mentioned under this act. However, with regards to online harassment, the government has already noted that the points shall be taken into consideration.
I want to give my recommendation to speaker. Thank you.
Thank you.
Thank you, Honorable Speaker, for allowing me to put up my opinions regarding this new labour code. Also, I want to highlight the case that my honourable member has just addressed about the teacher who has been harassed at the school institution. I want to specify that there are special guidelines, as the Vishaka guidelines, that follow for safety of the woman, but then crimes being committed. I want to highlight that what if a woman is being harassed within the premises of the institution or an organization? What are the particular rules that safeguards her even after the guidelines are being existing?
Indeed. As I have already previously mentioned before, the existence of a welfare officer is being created under this code, under this bill, and therefore if any woman is being harassed, she may approach preliminary the inspector appointed under section 20 of this bill, or she may approach the welfare officer of her enterprise, of her company. The government would also like to take into consideration the fact that the welfare officer may be created only if there are 250 employees or more working in an enterprise, which is why the government is specifically stressing on the point that any harassed individual may approach an inspector who is supposed to conduct inspections and surveys of each and every enterprise under sections 20 as well as 21 of this bill.
So, my honorable speaker, my honorable member of the parliament, I want to highlight the issue that even like the number have been specified as 250 employees per institution. What about the organization where there are less number of people being hired? And I also want to highlight that people at the highest positions of a country or whichever organization or institution are also subject to sexual harassment. Then what about the people? How are the women going to be safeguarded even after the guidelines are being existed and even laws are there? Even after the 2013 Amendment Acts, there have been so many instances where women have been harassed at workplaces.
Indeed, Honorable Representative, you make a very good point. However, the representative would like to further imply that there are already laws in existence. There is already implementation of these laws in existence. There are various labor unions constituted under various acts of parliament. Furthermore, the existence of the National Occupational Safety and Health Advisory Board will be in existence. Furthermore, inspectors will be coming to inspect and conduct surveys. There are already various preventive measures as well as after harassment measures which have been taken by the central government, and these have already been tabled before, been passed, and now we are now trying to pass this bill with regards to occupational and safety hazards. This all points that your honorable representative has been mentioned is already taken care of under various other acts of parliament and will be further taken care of under sections 16, 20 and 21 of the current bill.
My another recommendation would be regarding the health that the Occupational Code 2020 has been talking about, that there are maternity benefits, but there are no post-maternity benefits that has been mentioned in the code yet. And I want to even say one thing, that there is a custom in our nation where women do not declare their early pregnancies. What if there are medical checkups that has been doing prior to their appointment and even after at certain intervals? And what about if the woman, she's in her early pregnancies, how she's going to deal with the trauma and the physical trauma that she would be going through at her workplaces?
The representative would like to take note of your point. However, it is the government's job to frame laws with respect to women and pregnant women. The Maternity Benefits Act of 1961 is already in existence and has already been passed, and it already deals with post as well as pre-maternity benefits. Also, further sections of this bill state that creche systems have to be employed, have to be in existence in enterprises for women who have children under the age of 6 years old.
My only recommendation to the ruling party is that there should be a regular checkup of all employees, whether men as well as women, because there could be a sudden health deterioration that might occur, and even the ambulance services or immediate medical services cannot rescue the person. So there should be regular checkups or regular person appointed at places where such incidents might occur. Thank you.
Thank you. Your recommendations have been taken noted by the government. The honorable representative would like to continue with the section 4, with the chapter 4 as well as chapter 5 of this bill. Thank you, honorable speaker, for the permission. Furthermore, as the representative has already mentioned, section 20 as well as 21 of this bill does state the creation of inspectors cum facilitators to conduct inspections as well as conduct surveys, and they have the power to call any employee, any worker working in an enterprise to conduct a survey and to be part of the survey. They have been given all these powers and they do not require any permission of the employer to conduct these surveys. The honorable representative would like to move to section chapter number 5, which is a further continuation on the health and safety as well as the working conditions on each and every enterprise. The working conditions have already been mentioned as follows. There must be adequate amount of cleanliness and health benefits taken care of in every single enterprise. There has to be adequate ventilation facilities in each and every enterprise and each and every workspace, as I have previously mentioned, whether it may be an office building or whether it may be an on-the-site construction site. Furthermore, the environment should be free of dust, noxious gases, or any sort of gases that is supposed to harm the employees. Furthermore, there should be systems regulating humidity as well as air conditioning in each and every workspace. Also, the existence of potable drinking water must be made available everywhere throughout the facilities. Also, there should be measures regulating overcrowding in every single enterprise. And furthermore, lastly and most strongly, the representative would like to state before this committee that latrines and urinal facilities for each and every single gender is being taken into consideration. Be you male, be you female, be you transgender, you are being covered under this bill. Thank you.
Honorable Speaker of the House, Member of the Parliament, I'll continue with the chapter 5, which also mentions about the health benefits that the employees and the people are going to get in this code. This code has been actually the most specific center part of the code is about the workers and employees in the institution who are working really hard. The government has taken a step due to COVID-19. COVID-19 was a huge slap on our faces because it was an outbreak that we were not prepared for, and the people and the opposition has already blamed the central government for this because they thought that we were not prepared, and this is the reason why this code is in it. This is to help the workers and the employment. Yes, Speaker, please.
Honorable Speaker.
You may proceed.
Thank you for giving me the floor. I would like to object to this. My member of parliament, fellow member of parliaments have already mentioned that the weaker section has been covered. But you have specifically eradicated and ostracized the most important community, transgender community. Where have you mentioned? There is only 3 times that you are mentioning the transgender community. I would like to say that it is the first and foremost objection that the welfare of transgenders, which in turn curtail their rights and have a debilitating effect on their personal fundamental rights. How are you protecting their rights? My main objection is, where is the provision for their safety? Where is the provision for their safety?
I appreciate your point, but this was the point that I really appreciate, because I know a lot of people here has the same question about the transgender community, but I need to inform you that there is already a transgender act available in the
Honorable Member of Parliament, that is a central act. That is a central act. Why are you not mentioning it in the code?
When I say employment, I'm talking about all the genders. Why do you need a specification?
Then when you specify chapter 10, chapter 10 has specific mention of women, then why are you ostracizing the most important community? You make a act, you introduce a bill in 2019, you introduce some bill in 2019, then you pass an act, and why are you specifically removing them from the act? And you had a point, COVID-19 mein the ruling party did a lot of work, I would really appreciate that.
We did.
But one more point I would like to mention is, you specifically said this was an official statement. Please, Speaker, let this go on record that it was an official statement by the ruling party that you would be providing 1,500 rupees in every transgender's account. There are 4.5 million transgenders currently, according to the 2011 census, that is an estimation, and only 1,229 out of the 4.5 million population you have transferred the money.
I need to remind my member of the parliament that we are talking about the occupation, health and safety of the people in the working environment.
They are not getting employed.
If I am running an institution, I have 50 women working under me, 50 men working under me, and 50 transgender working under me. I am talking about all the workers and all the employees. Why do you need specification?
We need specification because you have specifically mentioned women. You have specifically mentioned women. That is the weaker section. That is the weaker section.
Members, please maintain the decorum.
That is the apologies, Speaker. Honorable Speaker. Member of Parliament, I would just like to mention it that if you are coming with a central act, which mentions the transgenders' protections and rights, then why are you specifically removing them from this act? I just need a specification. This is my recommendation. And also, when you say that we need a different code, because it needs to be specified, because they are one of the most vulnerable and most specifically ostracized part of the society.
Due to which the Transgender Act was already came into form. Transgender Act has been already formed. This is about the health, occupation of the people in the working. I am talking specifically about the employees and the workers. If a transgender is working in an institution, that transgender person is in a worker, comes into employee and workers.
Honorable Member of Parliament, have you seen the statistics of the employment of the transgender people? Have you seen it? No. It is an objection I would like to mention that transgender people are not at all employed. And the government should also notice this, that intersex, when you're referring to transgender, you're referring to the intersex community. Transgender is an umbrella term, and I would like to mention that you should take this specific recommendation, and my other recommendations I would like to pass through the speaker via chat.
I appreciate your recommendation, but still my answer will be the same, that we have already mentioned workers and employees.
Good morning, honorable speakers and honorable parliamentarians. I rose to speak about various welfare provisions mentioned in the chapter 6 of the OSH Code 2020. This code emphasizes on having washing facilities for male, female, transgender employees separately. Not only that, but also bathing places, locker rooms, restrooms, changing rooms, etc. Other than that, there is a special place. There's a special mention about having clothing exchanges where an employee has to change their clothes. Special places are provided for that by the employer. Other than that, in case of mines, proper medical examination of the employees before their employment and after their employment will be taken at specific intervals. In case of any minor injuries, there will be first aid boxes readily available by the employer. The central government also considers any other measure there is under set circumstances for better standard of living of the employees in the course of their employment. Apart from that, the code also mentions an ambulance room for workers more than 500 in an establishment. Also, in an establishment having 100 or more workers, there is a special provision for canteen facilities, and this includes contract laborers too. Also, I would like to talk about a creche, a common creche, and a specific room for the children under the age of 6. All in all, I would like to say that the code has availed a lot of amenities and lot of facilities for the employees and workers by the employer. Any objections?
Honorable Speaker, may I
proceed.
proceed? Thank you for giving me the floor. Honorable Member of Parliament, I have just one objection through the code and speaker, section 24, subsection 2 and clause 4. In the chapter that it states that welfare officer should be appointed in a factory which has more than 250 members. Now I would like to mention that what about the people or what about the industries where there are employees below 250? What about them? Why are you not employing welfare officer over there?
Member of the Parliament, thank you for the objection, because we need to clarify it for a lot of people here that we are not specifically talking about only the workers who are working above 250. There is also mention in the section that we are also talking about employees more than 10. We are specifically, my fellow speaker has already mentioned during chapter 1 of the code, that we are also talking about the people who have more than 10 employees. That will be benefit for the small businesses. We are also speaking about them. We are also speaking about the people working for 250 employees.
Honorable Member of Parliament, parliamentarians, Mr. Speaker, I will send my answer through the chat, via chat.
Greetings, Honorable Speaker. Thank you so much for giving me an opportunity to speak. I would like to present on the topic about the wages, leaves and hours of work for the employers, which is mentioned in the chapter 7 of this bill. So it is evident from the Paleolithic period that the workers and the employees are not treated in a manner that they deserve to be. And the things have changed a lot from those times. As we all know, it took a series of steps, changes and development to come to a place to reach where we are today. So the chapter 7 of this bill consists of 8 sections, that is from section 25 to section number 32. So section 25 prescribes a maximum work shift of 8 hours a day in any establishment, and this threshold can be lessened for the employees working in the mines. And coming on to the next section, which is section 26, which prescribes maximum of 6 working days and to provide with a fixed day off. And there's also a provision for the workers and the employees who extend their shift times and perform overtime duties. They are entitled to receive twice the wages that they get if they perform overtime duties. But there's also a special provision mentioned in the chapter, in the section, that the employer cannot force any employee or workman to extend their shift timings and perform overtime duties. And in the section 29, it prohibits overlapping of work shifts, where more than 2 shifts work on the same thing at the same time, but here is an exception for the mines. And as per the last section of this chapter, which is section 32, it states that the adult factory workers are entitled to get 1 day leave for every 20 days of work they do, and for the adolescent and mine workers, they shall be entitled for 1 day leave for every 15 days of work that they provide to the organization. And there is also a provision for carryover of accumulated leaves to the next year up to a maximum of 30 days. So the government has taken many aspects into consideration and have proposed this bill. So, and the House also knows that this bill is a great pioneering step in making things better. Any objections?
Honorable Speaker, can I have your permission to put forth my recommendation on the code?
You may proceed.
Thank you. Section 25 of code, as mentioned by the honorable member, section 25 of the code talks about working hours and annual leaves. The code mentions that no worker shall be required to work more than 8 hours. Well and good. However, my recommendation is that the code does not mention any specifications regarding the minimum time, minimum interval time that should be given to the employees. Also, I would suggest this, that specific timings, specific interval timings should be clearly mentioned, especially for pregnant women, so that all the women under the organized as well as the unorganized sectors can prevail this benefit. Also, my second recommendation is that under Article 15, Clause 2 of the Indian Constitution, thank you. The Article 15 forbids discrimination on the grounds of sex, race, caste, religion, and place of birth. The responsibility of parenting comes on the shoulders of both the parents. Inequality and gender bias cannot be done to women under the Article 15. Hence, the parenting responsibility should be there for both the father and the mother. Especially, I would like to highlight this point, that in the postpartum period, where the woman is recovering to her health, the men should be given special paternity leave for that. In countries like Sweden, Denmark, and Norway, very progressive paternity leaves have been and policies which encourages alike mothers and fathers to share their leaves have been mentioned. The new fathers can be eligible for 8 weeks of paid paternity leave, and they should get the option to choose the number of days they prefer to work in a week, slowly easing them back to come into their professional life. And lastly, my last recommendation would be about menstrual leave. Menstrual leave refers to a specific form of time for those women experiencing period pain. The menstruating period can cause severe discomfort, pain, emotional stress, and other health issues. Many countries like Indonesia, Japan, South Korea, and Taiwan have taken certain provisions and policies regarding the menstrual leave. In India, there is no legal infrastructure which mentions the right of women to take menstrual leave. Bihar is the only state that has government-approved period leaves. My question to this parliament is that such an important provision, such an important, utmost important provision, which should be included for the health and welfare of the women, why is it not mentioned in the bill? Why is it not mentioned in the code? Why are we lacking this provision? And it is my severe recommendation to the parliament to look upon these facts and consider the provision.
Honorable member, your recommendations are being respected, but I would like to point out on the menstruation part that you have just stated. Well, adding menstrual leave in this bill is acceptable. However, it must be noted that women will be subject to rude questions from their employees relating about their menstruation cycle or the menstruation days. We feel that this is morally wrong and thus we have not included it in the bill.
I consider your point. It is a very sensitive issue. But an internal committee can be set up of female employees. Exactly. An internal committee can be set up where there are female employees and the concerning female can reach out to them and mention her leave and her illness. And also I would like to mention that since your code mentions Maternity Benefit Act 1961, the Parliament has included maternity benefits to the women also. But the Maternity Benefit Act 1961 gives maternity benefits of 12 weeks to women for their pregnancy. But it nowhere mentions the paternity leave and menstrual leave. So why are we lacking these specifications which are very important and which should be included for the women and health welfare?
Okay, Honorable Member, I would like to correct you on one thing, that in the Maternity Benefit Act, the leave for the maternity is not 12 weeks, it has been amended to 26 weeks. But according to your recommendations, the government understands the points and shall think about it. Thank you. And Honorable Speaker, I would like to invite the next member to speak. Thank you.
Right? Thank you.
Good evening, respected honorable members, speakers of the parliament, and all the members of the parliament present here. Firstly, I would like to thank all the speakers for giving me this wonderful opportunity to speak in front of the court. So I have been quietly hearing by the opposition team members of the opposition that they were talking about the safety of women. So here, I'll be dealing with Chapter 9 of the Occupation Safety, Health and Working Code, Condition Code, which gives the appointment of the inspectors. Under the Occupation Safety, Health and Working Condition Code, the inspector cum facilitator is the primary authority responsible for the inspection and thus enforcement. It is important to understand the enforcement mechanism under the code. The definition clearly states that an inspector cum facilitator means one appointed under the subsection 1 of section 34 under the Occupation Safety, Health and Working Condition Code. The subsection provides that the appropriate government may, by notification, appoint inspector cum facilitators who shall exercise the powers conferred on them. I would like you to draw your attention to section 34 subsection 5, which also empowers the appropriate government to appoint a chief inspector than one state as well as for the whole country. It also states that no person appointed as inspector cum facilitator shall be permitted to hold any direct or indirect intervention to a workplace or work activity. I would like to draw your attention on the section that says all the chief inspector facilitator, additional chief inspector facilitator, joint chief inspector facilitator, and also the deputy chief inspector cum facilitator, and every other officers appointed under the section 34 of this code shall be deemed to be a public servant under the section 21 of the IPC, Indian Penal Code. Now let's talk giving about the powers of the inspector cum facilitator under the section 35 of the code. Facilitators is empowered to enter any workplaces for any inspection purposes. They can ask you for any documents, any copy of the documents. I would like to draw your attention towards section 38 of this code, which gives special powers to these officers, such as they can give an order in writing for, with regards to serious hazards and imminent danger, removal of such danger, prohibition of employment of persons, and so on. Lastly, I would conclude with the point, I would like to draw your attention towards section 40 of this code that mandates that every employer of an establishment must allow the chief inspector cum facilitator and every inspector cum facilitator or every person authorized by the inspector cum facilitator for entry,
Speaker, may I have your
inspection,
permission
survey,
to object?
measurement,
Let him finish first.
examination or inquiry under the code.
You may proceed.
Any
now.
objections?
I would like to draw the attention of this House to the section 38Q, subsection Q of this proposed bill, which provides that the central government can modify or reverse any order passed by the chief inspector cum facilitator under this bill. I would like to ask the honorable member here to tell us why the central government is the appellate authority here. How can the legislature intervene in the matters of the executive? This completely violates the principles of separation of powers between the executive and the judiciary. I would like to understand from the honorable member why the central government has not appointed a competent authority to consider such cases, and why is it misusing its power? Thank you.
Honorable Speaker, I just need to mention that the central government has appointed inspector. Central government, the opposition needs to understand that the central government is not dominating the court. They are taking responsibility for what should be done. They are just doing their job for the workers and the employment. This code is made for the benefit of the workers and the employment. The central government is not interfering into anybody's job. They are just appointing people who can do their job properly.
Honorable member, I would like to inform you that the objection over here is in regards to the appellate authority. Yeah. Whether the legislation should at all misuse its power and be the appellate authority where the executors have the right to do it.
There is no misuse of power because the central government has appointed people, and if there is a misuse of power, the courts, the High Court and Supreme Court are already mentioned in the code. You can, if someone feels like they are being unfairly treated, the courts are available. Thank you.
I'll send my recommendations to the chair.
Good afternoon, everyone. My sincere greeting to the jury members and my fellow mates. So, I have a due concern for the hardship faced by the laborers, and that's why the government came up with this code. It has always been the endeavor of the government to mitigate the suffering faced by the weaker section of the society. That's why the government came up with this code. I am dealing with the chapter 11, which has 9 parts. Now, this code has specifically talks about interstate migrant worker, the worker which are working in the mines, the worker which are acting in the factories, and offenses and penalties that has been talked about. Now, I would like to further elaborate on the 5 point which this code has specifically mentioned. Earlier, the employers has not been targeted, but in this code, the employer has also been targeted. The ruling government has tried to lessen the burden on the employer as well. The workplace should be kept from hazardous that cause or likely to cause injury or occupational disease to the employer. Now, I would like to mention that the government has also tried that employers should be required to ensure the disposal of hazardous waste, specifically e-waste. The government had tried in disposing of the e-waste also. Any objection?
Yeah. Before concluding the arguments, I would like to state that the 3 speakers who like to put forward their recommendations in front of the Parliament.
Honorable Speaker, I have heard carefully to the respected member. I would like to put some recommendations forth, as in the entire provision under Section 61 does not state anything about the displacement allowances given to the interstate migrant workers. It does not even state anything about the emergency situations for the interstate migrant worker, and does not even take into consideration the privileges given to the worker while they are commencing the journey. During the period of the journey, no wages are given to them, and that is not considered in this code.
The second recommendation by our board.
Honorable Speaker, thank you so much for giving me this opportunity. Actually, the objection is related to Chapter 12, Section 103, which deals with the penalty given to the employer in case it contravenes the bylaws and the laws given in the code. So the penalty given for the death is 2 years and 5 lakhs, and in case of serious injury, it is 2 to 4 lakhs. And also the provision is given that 50% will be of the imposed fine will be given as a compensation. My question is to the ruling party that why such insignificant amount is given as a penalty. So hence my recommendation would be that the penalty should be deterrent enough that the employer is vigilant so that there is no safety hazards. If you look at the data of industrial injuries is always showing an upward trend. Means there is a lax in safety and health and working conditions of the workers or of the labor class. And the second recommendation would be from Chapter 12, for Chapter 12, Section 125, which deals with no civil court has a jurisdiction for hearing matters under the code, and no injunction shall be given by the civil court for the matters under the code. So my recommendation is please do not bar the civil court, as there are many we are denying the opportunity for the aggrieved person, and hence that would be my recommendation to set up a proper judicial mechanism and proper judicial procedure. Thank you.
Honorable Speaker, sir, I would like to draw your attention towards Section 127(2) of the Occupational Safety, Health and Working Conditions Code, as it subsumes 13 acts including the Factories Act. The 2020 bill, which is allowing the state government to exempt any new factories from following its provisions in the interest of economic activity and employment generation. My issue over here is, how can you exempt a factory and exempt any new factory in this sense from following the safety norms? This is the basic safety right of the employees. If you are making a code and if you are talking about claiming it to be in the workers' favor, how can you exempt this basic rule? This was also mentioned in the Factories Act of 1948 under Section 5, which clearly mentions the provisions under which it can be used, which specifically mentions public emergency, and the time period should not exceed more than 3 months. My issue over here is this code is not specific and does not mention any specific time provision.
Members, this session has been timed out.
Can we conclude the last statements? 2 minutes.
2 minutes.
जगाते जगासाठी आयुष्यभर माय मातीचा आधार, नाही कोणाची लाचार माझ्या भूमीतला कामगार. This code talks about occupational safety, health hazard and working conditions code 2020. This code is built to fill up the lacunas which have been in the 13 provisional laws which are already legislated. But then again, the lacunas have not been properly fulfilled because the definitions have not been clarified, the safety and health of the workers have not been taken completely into consideration. Those bridges have to be compensated. The discretionary powers which have been given to the state government have to be specified for the perfect implementation of this code. I would like to say it in the end, as the code and the slogan of today is मुट्ठी भर आसमान पर एक हक हमारा भी है. तो क्या आप ये एक हक पूरी तरह उस कामगार को दे सकते हैं, और किस तरह देंगे वो हम रूलिंग पार्टी से जानना चाहते हैं. Thank you. Please take our recommendations into the code.
Thank you, fellow speaker.
To conclude, I would like to stress on the fact that the socio-economic developments can play a great role in eliminating evil tendencies. With these words, I strongly support the bill, and I thank you for having given me this opportunity to speak.
I declare the Occupational Safety, Health and Working Condition Code 2020, Bill number 37 of 2020 as passed.
Motivation gets you going, but discipline keeps you growing. Thank you so much, team from the Rizvi College. You have been wonderful today. It was very disciplined and articulated session, I must say.